Good evening and welcome to this evening's webinar. We are talking about planning for retirement and pensions from an estate planning perspective. So both structuring your assets and your superannuation and how that works in your estate planning, but also if you're doing your estate planning and you have beneficiaries that are on pensions, it's important that your estate planning takes that into consideration so that you don't knock them off their pension when you don't intend to after you pass away. Now, I will take questions. For those live, you can use the Q&A box or the chat box to pop those in. I can't see them while I've got my screen shared with you, so I will come back to them at the end. For those watching the replay, if it's sitting in a replay screen, there will be a place to submit a question that gets emailed to me, and I will respond to that within 24 hours. So let's see how we go. I'll just explain a little bit about who I am. So my name is Jackie Broman. I'm the owner of TBA Law. I am also an accredited specialist in wills and estates. So as a qualified solicitor, I can practice, but then I went and did an additional master's degree on top of my undergraduate degree. And then after that, each law institute or law society in each state has an accreditation program. They're fairly consistent across the states, but it's an extra 12-month program that I went through, had examinations at the end, and so can also say that I'm an accredited specialist. So there are a number of different areas of law that people can get accredited in. I'm in wills and estates, and just to give you some perspective, there are about 22,000 lawyers in Victoria, and only 80 of us have this wills and estates accreditation. And then the other photo there is just a little bit about me, because I am more than just a lawyer. Those are a couple of my loves. So my dogs and my fishing are a couple of things that feature heavily for me. And this is where they meet. And this particular dog has to be tied up when he goes fishing because he would jump over at the white water in a second if he could. So enough about me. Let's get into what estate planning is in 2020. And I like to use a comparison of maybe 50 years ago in terms of estate planning, because estate planning probably wasn't a thing 50 years ago. You probably just did a will 50 years ago. But now a will is not enough. Life has got far more complex. We own more property than people would have 50 years ago. 50 years ago, people's dream was really to have a house. But these days people might have multiple houses. They have various ranges of investments. Tax laws have significantly changed to become more complex. Superannuation is now a compulsory thing. So we do have to deal with superannuation too. 50 years ago, it was pretty rare. People are living longer as well. And so we need to take into account how people's health changes as they age. It's not like people retire and then live for another 5 years and pass away anymore. People are living and potentially their minds are outliving their bodies or vice versa. And all the pressures that come with that. And hence, that's why estate planning involves powers of attorney as well. Also our, I guess, level of healthcare and the ability to keep people alive has also significantly improved. And so even if someone were to have a serious accident, people are more likely to survive. They may have a period in a coma or a long period of rehabilitation. And again, powers of attorney are very relevant for that situation. Advanced healthcare directives come into play with powers of attorney, so being able to leave instructions about what you want for your healthcare if you can't participate in those decisions. Trusts are relevant because people, as I said before, they're structuring their investments more. There's more complexity in the way they structure their investments these days, and quite often people have family trusts or other trusts, but also we need to think about the sort of trusts that you need to set up in your wills, which was a very different sort of trust than, again, they would have used 50 years ago. They used some fairly simple trusts back then, but we can do far more complex and flexible things these days. Guardianship has always been something to consider, but I think that particularly with more and more blended families and separated parents, considering who should be your guardian is even more of a requirement in your estate planning. And then also leaving instructions about how you want your children raised, what sort of extracurricular activity you'd like them to do, how you want them to be disciplined, how you want them to grow up with pocket money, all sorts of elements. So there's your overview. Now let's jump into what is relevant in your estate planning when you are looking to retirement. And the first thing to consider really is whether you can qualify for a pension or not in retirement, a Centrelink government pension. So more and more people will be self-funded retirees, but there will be a lot of retirees who will have a small pension from their superannuation, but will also top that up with a Centrelink pension. Now, Centrelink rules have been tightening up. The way they're doing the asset test is changing for the pension. How much you can own outside of your principal place of residence is constantly moving and coming down relative to average asset holders. So I guess the primary aim for the government is to have less and less people qualify for full pensions, but quite often the aim can just be to have a part pension. So if people come to us early enough to do the estate planning, essentially what we're looking at is restructuring the ownership of their assets so that Centrelink doesn't count them as an asset for the asset test for the pension. Now, this can be done in a number of ways, but we also need to have sufficient time to be able to do it. And Centrelink has a 5-year rule, 5-year gifting rule, which has trapped people before. So when you restructure your assets and you move them out of your name, Centrelink will still count them as your assets for 5 years. So you don't want to be doing your restructure, you know, a year before you want to apply for a pension. You want to do it with enough time in mind. And in fact, particularly for farmers, I do a whole lot of restructuring of their assets in their 50s usually, in preparation for a transfer of the ownership of those assets before the farmer then reaches 65. So you've got to think about your 5-year rule. Now, what is the cost and how do you get rid of assets that are in your name but still have the benefit from them? Well, that's the tricky thing, because for the average player, you really can't. So even if you had started growing your investments in a family trust from the get-go, Centrelink counts a family trust and the net assets in a trust as assets in the asset test. So even if you had your assets in a trust, you can't benefit. There are some financial products that you can buy that still give you like a pension income that don't get counted as an asset. So that is potentially something to look at, converting some of your the type of assets that you own into something that isn't counted. In terms of real estate, particularly when you're thinking of farmers, it's a little bit easier for farmers because they have stamp duty exemptions when they're transferring land. So if they're transferring land into family trusts, and then as they get closer to retirement, they effectively renounce any benefit that they have under that trust. It's very cost effective. But if you have investment properties and they're not primary production land, which is the majority of people, then you can't get those out of your name without paying stamp duty, which is the big thing that prevents people from doing a really effective estate planning while they're alive. The stamp duty taxes and the capital gains taxes really incentivizes people not to transfer things while they're alive, but instead do it under a will, because then it's all tax exempt. So you get a bit trapped. And then the other thing is, even if you paid the stamp duty to move real estate out of your name and put it in someone else's name, then the income from the rent goes to that other person and they get taxed on it anyway. So you're potentially penalizing someone else in your family for taking on the asset just so it's not in your name, just so you can get a pension. So the asset and income test for a pension, as much as we think that it is tough, and in some respects it is still calculated on the basis that if you can't qualify for a pension, you're probably better off not on a pension. So there's Centrelink. Now, one other thing about Centrelink is particularly for disabled people. Now, disabled people do have some extra exemptions, and there is a type of trust that a disabled person can utilise to move assets into, which then are not tested on their asset test. So they can have up to $650,000 of assets in a special disability trust, and it does not count towards their asset test. So it wouldn't affect their pension. So that potentially is a way to leave money to a disabled beneficiary in your will. So that just there piques your interest, because we're going to come back to that in a second. So superannuation is obviously very relevant when you're thinking about retirement. And I have done a couple of webinars with a financial planner who talks about superannuation from a different perspective. And if you would like to watch those, I can send you that link if you let me know. And what they particularly talk about is making sure that your superannuation moves from a unit-based fund and moves into a cash-based fund. The people who had a unit-based fund in the GFC and now potentially during the COVID crisis were impacted much more than people who had cash-based. So I'm not talking about cash assets, I'm just talking about how the funds are invested and not invested in a unit that is worth a certain amount. It is just invested at a dollar, on a dollar basis. So you do need to think about maybe restructuring how your super is invested through your fund. And if your fund doesn't allow you to move away from a unit style investment, then you can shift funds. It does not cost you anything to roll funds out and into another superannuation. There's also the consideration whether you take a lump sum or not out of your superannuation. So that is something to consider and get financial advice on. But superannuation tends to be performing better than non-superannuation investments at the moment. You wouldn't want to take it out of super and put it in a term deposit at the moment, because you're getting about 1%, maybe even only 0.8% on a term deposit. Now, from an estate planning perspective, we need to think about moving superannuation from you to your beneficiaries. And so if we think about spouses first, superannuation transfers from one spouse to another on death, tax-free. Okay, so you wouldn't really want to bypass your spouse and leave it all to your kids. Your spouse, your main obligation is to your spouse as well, but there's the tax benefit of doing that too. So there's a tax-free transfer. Now, when you move from accumulation phase in your superannuation and move into a pension phase of your superannuation, it is a different classification for your super, and it opens up the ability to leave a reversionary pension to your spouse. So only a spouse can have a reversionary pension, except for children under 18, but not many people in retirement would have children under 18. So know that if you pass away and your fund is still in accumulation, a lump sum has to come out of super and it goes to your spouse. If your superannuation is in pension phase, you can leave a reversionary pension to your spouse, and so it stays as superannuation, and the superannuation just transfers to your spouse. Okay, so it doesn't have to come out as a lump sum. So that is something to think about, whether you want to think about lump sums or reversionary pensions. The other thing to think about as well is the superannuation cap. Now, this is for the more wealthy players, the people who are on self-funded retirees and people with self-managed super funds. Now, you now have a cap that is introduced on your superannuation. So again, another thing, like the government is moving the goalposts. On the one hand, they're saying, you know, we want you to be self-funded, put as much super money into super as possible. And then on the other hand, they say, but you can only have $1.6 million in pension phase at any one time. So if someone has more than $1.6 million in their pension phase, any other superannuation they have has to stay in accumulation phase. So you can see the difficulty in terms of transferring that. You can only leave a reversionary pension for the pension phase bit, and then accumulation has to come out and paid out as a lump sum. So that's really tricky, particularly if your spouse also has, you know, another significant portion of superannuation. Because then if you have 1.6 mil and you want to leave a reversionary pension, you can only top them up to 1.6 mil, and the balance has to be paid out as a lump sum. So really tricky and annoying in some respects, but that's why it's so important to do your estate planning as smart as you can. The self-managed super funds as well can be quite tricky in this situation, because if people in their self-managed fund have invested into real estate and say they have, you know, 3 or 4 properties in Melbourne, each worth 800,000, one person has 2 of those properties in their account, so 2 properties, which makes them up to 1.6, and the other person has the other property, 800,000, in their pension phase for their super. So you can see that then if either of them died, there'd have to be at least 1 property sold in that super fund, and the lump sum has to come out. So not great. And then they end up with a cash lump sum, which then they have to look to reinvest. They might be able to reinvest some into super, they may not, but then they have 800,000 in cash that they then have to try and invest. And if property has the best return, they then have to buy something else, or they have to sell it to themselves or something. So just bear in mind the complexities around superannuation and the importance of planning early before retirement and making sure you've thought about the reversionary versus lump sum and making sure those nominations are done so that it's guaranteed that it will go where you want it to go. Because remember, your will does not cover your superannuation. I've covered a lot of that in another webinar I've done, specifically on superannuation. Okay, so now talking about vulnerable beneficiaries. And this can also be your spouse, right? So you have joint assets and you may qualify for a part pension while you're a couple. But then the first of the couple passes away and it all goes to the surviving couple. And then the asset test may be such that it kicks them off the pension. So again, in the estate planning phase, we look at what assets there are, how much it is, and how it's owned, and what the impact is if one of the spouses passes away. Do we, instead of leaving everything to the spouse, put some money somewhere else? Leave it to someone else? Or do you then think, well, actually, maybe I should do that round the world trip. Maybe I should get a new car, because those things, you know, you spend some money, you depreciate some assets quickly, you do some renovations on the house, all those sorts of things. So you do need to bear in mind, even transferring from 2 spouses to 1 can knock the survivor off the pension. Then we're also thinking about if both spouses have passed away and you've got children, and if one of those children or more than one are on a pension, how does that impact? Now, if you want to divide things equally between your children and they're on an age pension already, or I was going to say a disability pension. Some people on a disability pension can be impacted, yes. I mean, there's really not much you can do. Even if you put it into a trust for them, it is still counted. Like I said earlier, Centrelink still counts the assets in a trust as in part of the asset test. So I have set up secret trusts for people before. It's not my preference because then you have to really trust the person that you're leaving the funds with, that they'll actually do what you wish them to do, because it's secret. So the face of the will and essentially the world, there's nowhere in writing does it say what you want. So it's absolutely completely in trust. The other option, as I was talking about before, is a special disability trust. So for those parents who have a disabled child, whether it's a physical or mental disability, and their child is on a disability pension, a special disability trust may be the perfect solution. To qualify for a special disability trust, though, you have to be more disabled than just being able to get a disability pension, unfortunately. So those on a disability pension that have depression will not qualify. Those who are on a disability pension because they cannot participate in the workforce and have to have some kind of help in their home. So whether they are in assisted living or whether they qualify for someone coming in a couple of times a week to assist them in their home, they're likely to qualify for a special disability trust. Now, as I said before, about 650,000 can be put in there as inheritance, and Centrelink doesn't count it. So it's a wonderful solution. The trust then automatically says as well what happens once that disabled child passes away, because if a child is that disabled, they're unlikely to have children of their own. So then you'd want it to go back to your other children, or if they have had children and it's a later in life disability, then you can specify it goes to their children on the death. So it never actually ends up as an asset of the disabled child themselves. So the disabled child then really doesn't have to do a will of their own, because the trust itself determines what happens to the money that you've put in there. There are other trusts we could use, but as I said, they tend to be counted. Potentially what could be done is that the executors get directed to buy a person a principal place of residence if they haven't already got one. Principal place of residence at least isn't counted as an asset, so maybe that's a way around it as well. All right, so there's some options, but again, with enough time and planning, there's ways and there's creative things that we can do. So that is the bulk of what I'm talking about tonight. I'm again reminding you of all the aspects in the estate planning process. So this little poker chip is in fact everything that we cover that is included in our standard family legacy plan that we do for a couple. We do it for individuals as well, but it's primarily aimed at couples. So we look at what is owned, how it's owned, and what values things are. We do wills, powers of attorney, appointment of medical treatment decision makers, and advanced healthcare directives. So those are essentially the main documents you get. We also look at your superannuation though. As I said, your will doesn't cover your super, so we need to make sure we do those nominations on your fund. And because we've helped with the will, we can then strategically advise you whether we want it to go through the will or whether we want it to go directly. We consider testamentary trusts as part of setting up the will. Now there's multiple sorts of trusts, life interests. We've talked about the special disability trust. There are protective trusts. There are discretionary trusts. There are education trusts. There are minors trusts. So a whole lot of things that we can do. We look at your life insurance, not so much TPD, but definitely life insurance, because similarly to super, on some life insurance policies, you can make a nomination directly about where you want the insurance to go. Otherwise, a lot of policies default into the will. So we just need to know that so that we can take that into account with the planning. If we're doing this for a couple who still have young children, or potentially for a grandparent who is looking after a grandchild, we go deep into guardianship and instructions for guardians as well, which goes into a separate document. If people have family trusts for investment purposes or for running businesses, we look at the succession of those. We look at the transfer of power. We look to see whether there's trust deeds need altering. We then also cover off a couple of things that sometimes people want in wills, but we discourage them. I don't want a whole list of all bits and pieces that you want to give to people in your will. So we talk about having a personal effects list, how to set that out, where to keep that, how it relates back to the will, and then memorial instructions as well. Again, funerals often happen before anyone even looks at a will. So we do want to make sure that it's in the right place. So that's what is in our family legacy plan. Now, a lot of people are worried about doing estate planning because they think it's a huge process, that it's scary. And in some ways, I've made it look very complex. But the thing is, the way that we guide you through, we're doing a lot of the thinking and the strategy in our head. We're setting out our advice. It will seem very simple from your perspective. It's 2 appointments over a period of 2 weeks, and then it's all done. When you contact us and make an appointment, we send you out an email with all the initial information. It just gets you to think. You don't necessarily have to complete the stuff and get it back to us. In the first appointment, we guide you through all the questions we need. We will have everything after the first appointment that we need to draft you documents. Between the 2 appointments, we draft everything. We send you the drafts. We finalize them by email. If there was something that you didn't have with you at your first appointment, we get those. So whether it's trust deeds, superannuation deeds from your accountant, whether it is checking your superannuation policy and your life insurance policies, we do all that in between, so that at the second appointment, we have everything ready to go. You sign it, they're all valid from that second appointment. In terms of the delivery, After you sign and all the documents are valid, there's just a couple of things that we do. We get the binding nominations to the super fund. We make sure all the attorneys you've appointed in powers of attorney have done their acceptance pages. So those sorts of things. And then we deliver you a set of certified copies, so you have those at home. So that's the process. Now, what does it cost, do you say? So look, because we're based in the country, we don't have the overheads that some city firms do. City firms will charge you easily $3,000 for all of this. Our cost for a couple, that's not each, that is for 2 people, is $1,100. For a single person, it is between $750 and $880 for the process for an individual. Okay, so that's what you're looking at with your estate plan. In 2 weeks' time, it can be all done. So I've come to the end. That is my direct email address. You're quite welcome to email me any questions. Within reason, I will get back to you within 24 hours. So I'm now going to take some questions. If you've been furiously typing anything in the chat box, we will now go to those. And then for those on live, I will stop recording and take your questions in a minute. So again, anyone watching the replay, by all means, email me either directly from this screen or on the screen that the replay is embedded in, there will be something for you to click to submit a question. So I am going to stop the recording and wish you all the best of luck. Hope to hear from you soon.